We'll go straight on to clause 59. Dispose of clause 58 is before lunch. So clause 59, honourable members, there is an amendment proposed to this clause as appeared in the provisional business paper number 63. Let me ask the Minister to move the amendment. Honourable Minister.
Thank you, Mr. Chairman, sir. I move that clause 59(1) is amended by substituting paragraph F with the following. F, on a casual basis, or G, to act in opposition. Thank you. The purpose of this amendment says for immediate include not casual inside of bill. Thank you.
Thank you, Honourable Minister. Honourable members, if I put a question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Any good amendment for including casual? The only issue, of course, in the human resource management, day-to-day management, that this casual designation does not become misused as was, I'm not sure whether still is, but the case law held there. You have these officers who are on casual contracts who are not casual employees at all. They should be in permanent. They should be in permanent appointments. So I'm good. You may provide them, but provide them for through one way by casual start now. Thank you, sir.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Thank you for that comment. We'll take now. Thank you.
Thank you. And further comments on that proposed amendment? If not, I'm going to put the question. The question is that clause 59(1) is amended by substituting paragraph F with the following. F, on a casual basis, or G, to act in a position. Those in favor, say aye. Aye. Against, say no. I think the ayes have it. Ayes have it. Clause 59 therefore stands amended accordingly. Before I put the question in respect of clause 59, does any member wish to comment on that clause as amended? Thank you. If there's none, let me put the question. The question is that, Honourable, the question is that clause 59 as amended stand part of the bill. Those in favour, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 59 as amended, therefore stands part of the bill. Clause 60. Any member wish to comment on this clause before I put the question? The findings are on pages 51, 52 of the report. Any comments on that clause? Thank you, Honourable Leader of Opposition.
Thank you, sir. Clause 60, subclause 4B, so an extension to a probation period the provision is, can only be extended once. Is that correct? No further extensions after that.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Honourable Leader of the Opposition. Yes, the answer to this is yes. The probation can only be extended once. So after 6 months, if the supervising supervisor may look at that person still need to perform to the expectation, then also extend him to another 6 months. Thank you.
Thank you, Honourable Minister. Honourable Leader.
What happens with OSMU Minister where probation probation retire of probation now? What happens in those situations?
Honourable Minister.
Thank you, Chairman. Thank you once again, Leader of Opposition here. So, in that case, the oversight by Quebec Law Administration, and according to the practice now, the Commission shall be given appointment, law that one as a blanket appointment. Thank you.
The Honourable Minister, any further comments? Otherwise, I will put the question. The question is that clause 60 stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 60 therefore stands part of the bill. Clause 61. Any comments on this clause before I put the question? Clause 61. Sorry, there is an amendment proposed in this clause. Apologies for overlooking it, but as appeared in provisional paper. Let me ask the Minister again to move the amendment. Honourable Minister, please.
Thank you, Chairman. Thank you. So I move that clause 61 is amended as follows. A, substitute the heading code transfer, unquote, with code posting, unquote. B, at subclause 2, substitute code transferred with, unquote, with code posted, unquote. C, at subclause 3, substitute code transferred, unquote, with posted, quote, unquote. Thank you.
Thank you, Honourable Minister. How to explain the proposed amendments?
Thank you, Chairman. Yes, the purpose of this amendment is just for cater for the transfer law and the posting and thank you.
Thank you, Honourable Minister, Honourable Members. Before I put a question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
What now? Difference between transfer and posting? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you. Yeah, so transfer is when you go from one ministry to another. And that one normally the commissioner by him approved, posting ceremony done by the PS number.
Thank you, Honourable Minister. Any other comments on that clause as amended? If there is none, let me put a question.
Chairman,
Sorry, Honourable,
need to be clear no more. The amendment is made to clause 61(2), yeah? To A, B, and C.
That's correct. And the heading of the
The headings.
section.
Oh, okay, okay.
For the comments, okay, let me put a question. The question is that clause 61 is amended as follows. A, substitute the heading transfers with posting. B, at subclause 2, substitute transferred with posted. And C, at subclause 3, substitute transferred with posted. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 61 therefore stands amended accordingly. Before putting a question on that clause as amended, any comments on that clause as amended? Thank you. If there's none, I'm going to put the question. I will put the question here. The question is that clause 61 as amended stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 61 as amended, therefore, stands part of the bill. Clause 62. Honourable members, there is an amendment also proposed to this clause as appeared on the provisional business paper number 63. Let me ask the Minister to move the amendment. Honourable Minister.
Thank you, Mr. Chairman, sir. I move that clause 62(2) is amended as follows. A paragraph A remove, quote, not, unquote, before, quote, a vacant position, unquote. And B, at paragraph B, substitute secondment, or quote, secondment, comma, posting, study, leave, or suspension ends, quote, unquote, with quote, position is substantively filled, unquote.
Thank you, Honourable Minister. Perhaps elaborate on the intention behind the amendment.
Yeah, so this amendment, so it's just to clarify whether acting in position must ensure that position is vacant for an officer to act in that position. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? If it's straightforward, I'm going to put the question. The question is that clause 62(2) is amended as follows. A, in paragraph A, remove not before a vacant position, and B, at paragraph B, substitute secondment, posting, study leave, or suspension ends with position is substantively filled. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 62 therefore stands amended accordingly. Before I put a question in respect of that clause of clause 62, does any member wish to comment on that clause as amended? Thank you, Honourable Leader of Opposition.
Sir, just in terms of 62 subclause 1, lo A, B, C, D, emi time frame, emi for more than 6 months. What about for less than 6 months or 6 months and less? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. So may not get it clear that question, please. Can you just repeat yourself,
Honourable Leader.
Yeah, thank you, sir. Clause 62, subclause 1, A, B, C, D, the time frame used there, where an employee may be appointed to act in a position of another employee is on secondment, on duty, on study leave, or suspended for periods of more than 6 months. Then Narwansa will upload that position. But what about if it is less than 6 months?
Thank you, Honourable Minister. Thank you, Chairman. Thank you, Leader of Opposition. Yes, so two things you must have done here. If I'm under 6 months, you must have served that duty. But if I'm sometime more than 6 months, then you must have pay that person who I'm take him on the second mania, remunerate him for kind of extra duty.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Thank you, sir. So, less than 6 months, share him duties here, or man doing a little bit extra workload here, or no pay? More than 6 months, no, you pay?
Honourable Minister.
Thank you, Chairman. Thank you again, Officer Leader. Yes, so time him set him duty, he may also pay me our responsibility allowance. Thank you.
Thank you, Honourable Minister. Any further comments on the 62 as amended? If not, I will put the question. The question is that clause 62 as amended stand part of the bill. Those in favour, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 62 as amended, therefore stands part of the bill. Clause 63, does any member wish to comment on this clause before I put a question? The BLC findings are on page 52 of the report. Any comments on that clause? If there is none, I will put a question. The question is that clause 63 stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. Clause 63, therefore, stands part of the bill. Clause 64, again, there is an amendment proposed to this clause as appeared in the business paper number 63, and let me ask the Minister again to move the amendment. Honourable Minister.
Thank you, Mr. Chairman, sir. I move that in clause 64, 1C, insert code, probation, unquote. Purpose of this amendment is just to make that for paragraph M clear now. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? If it's clear enough, I'm going to put the question, and the question is that clause 64 1C, insert probations before permanent appointment. All those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 64 therefore stands amended accordingly. Before I put a question on the clause 64, does any member further wish to comment on the clause as amended? Thank you, Honourable Leader of Opposition.
Just in terms of categories, this was list law 1 here, 64.1. So you got retirement, resignation, and so forth. Sometimes, I don't know whether it's a regular occurrence, but sometimes all of the employees just go no more, no come back now. Or him go for a long time. Then him just try to come back more, but at what point do they self-terminate? Or does that category not exist? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman, and thank you, Leader of the Opposition. Yes, so normally we would give him a whole 3 months, him have to reply. After 3 months, salary him should cut now. I mean that him employment him terminated. Thank you.
Thank you, Honourable Minister. Honourable Leader of Opposition.
3 months, yeah. A little bit long time. So by 3 months, we're receiving full pay and go run on business plan. He may give warning more. 30 days, I think enough now, man. Even 30 days, we are generous for good, but thank you, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Yes, so this one became practice come before. One of the issue of public service are facing now because of the transport. Sometimes person want to go for leave, but then the transport no comfortable to come back too. So that's why I think this for 3 months it was given just ample time for others are able for come back to work or even right back to the PS. Thank you.
Thank you, Honourable Minister. Honourable Leader.
Yeah, thank you, sir. I mean, this one, you may use him reasonableness no more. If man him no come back for 3 months, but him start no kakabona no more. No any excuse straight. But if him lo anuta, oh yeah, no more 1 year. Because sip no sa kakasim lo de. So Sem reasonableness through ante on sem padol kami mi no sabe na. But for fixing no more than 3 months across the board for everyone, I know no mas here good man. So
Thank you, Honorable Leader. Honorable Minister.
Thank you again, Chairman. Thank you, Honorable Leader. So, in this bill, by me addressing what issues along public service order. Thank you.
Thank you, Honorable Minister. Honorable Chair, PAC, Central Honiara.
Thank you, sir. Sir, to subclause 2B, delayed retirement. So, compulsory retirement would be 55. Then we say it's delayed. Why would it be delayed? I mean, and how not by delay there have been affected? Will he be given another couple of years for him delay, or how was that trigger? Thank you. Is it a retirement?
Thank you, Honorable Minister.
Thank you, Chairman. Thank you, Chairman of the PAC. Yeah, so two things can happen here. One for the delay can go for 2 years. The other one is so we can get them on fixed term employment after retirement.
Thank you, Honorable Minister.
So,
Honorable PAC Chair.
yeah. So, where the compulsory retirement and me trigger, and finish now, and retire now. So, the next one would be an extension, possibly under special engagement now. Is that how by me read or how?
Thank you, Honorable Minister.
Thank you, Chairman. Thank you, Chairman of the PAC. Yeah, so the commissions are also doing what I call deferred retirement here. Again, it's based on the circumstances surrounding the staff and also the need for the work. Thank you.
Thank you, Honorable Minister. Let me now put a question. The question is that clause 64 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 64 as amended, therefore, stand part of the bill. Clause 65. Does any member wish to comment on this clause before I put a question? Clause 65. Refer to the pages 53 and 54 of the Bills and Legislation Committee report. Any comments on that clause? Thank you, Honorable Chair of the Bills and Legislation Committee and the MP for West Harare.
Thank you, Chairman. 65(1), Minister Hemlek for keeping 55 years, yeah? Interest in Kakampi for committee now, for Mumufuma, looking 55 years, Staka Ian Manit, yeah? Ian Womanit. Looking low house, yeah, everyone was under 19 no more. So we were recommending that Miss Mumufuma, if Minister and me care for just explain when I'm 55 years, I'm like for keeping. Thank you, Chairman.
Thank you, Honorable Minister.
Thank you, Chairman, and thank you, Chairman of the Bills and Legislation Committee. The 55 years, me come under the Labour Act, the Labour Act. But then if you look at Section 66, there is voluntary retirement there as well. So I'm still give flexibility. Whoever wants to retire early can go at 45. Thank you.
Thank you, Honorable Minister. Honourable Leader of Opposition.
Law 65 3 minimum time you 65 1 year apply, time you 55 years, of course, so I give him you fixed term appointment. How many fixed term appointment, how many years here? Is it 1 year or 2 year or annual thing? And how many of these can you keep recontracting, reappointing before you cannot continue?
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Yes, so the initial that fixed term as contract can be for 2 years and can be extended for another 2 years. And after that one, I think only one extension under the fixed term contract. Thank you.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Yeah, thank you. So 55 plus 4 years, 59. Young man yet, but you know, I'm experienced surgeon law inside the operating theatre, or an experienced geologist and or engineer, or technical people who have built up years of experience, but you may need him inside law service, and you might need him more yet. We probably will need them actually more. So perhaps flexibility should kick in law there as well. Of course, time you may start for Kakasim 60, so something you may not remember good, but it's, you know, it's a case by case basis. All man remember everything. All man no must remember everything all same. But it matter for recruitment process here for determining. Law ogata nara classification administrative also no any real burden to keep them on, but the technical ones surely more years experience is valued. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Opposition Leader. Yes, so most of these technical people, you mean by addressing the issues here through the contract explorer, technical people will be contacted there. So those issues here by addressed inside the contract in terms of skills transfer and other important technical areas. This one again, it gives an opportunity for other new technical people to come into those positions as well, which will be addressed through training and other areas of skill improvement. Thank you.
Thank you, Honourable Minister. Honourable MP for East Arare.
Thank you, Chair. On 65(2), A and B, in terms of this context of retirement, yeah, on medical grounds, and we look into there, 65(2)A, and I think that is pretty much straightforward. They must assess him through some sort of quantification process in terms of how now medical considerations to be given. But the next one, 65(2)B now, I'm saying on public interest grounds. One and now that might be public interest grounds. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for East Arare. Yes, so this one is really based on if someone has not performed to the expectation, as we talk about him in any position, we're doing it on behalf of the people. So in terms of the performance, if he has not performed to the expectation, then that's where this one himself come in. You must take up this one for coming. Thank you.
Thank you, Honourable Minister. Honourable MP for East Arare.
Thank you, Minister. And then at the end of the I'm saying another reason also, for retirement no more. I mean, this is the whole context of 65. So one name now, another reason that you might think beyond more. One name you just explain him, come, Minister. Thank you.
Thank you, Honourable MP. Honourable Minister.
Thank you. With regards to that inability or another issue, one could be the person could be posing some risk to to get the team's blend. I think that could be also another reason why him should discharge him. Thank you.
Thank you, Honourable Minister. Any further comments, Honourable Leader of Opposition?
Oh, so what kind of risk here, Mr. Chairman?
Thank you, Honourable Minister.
Thank you, Chairman. Yeah, and thank you, Leader. Yeah, I think there's a lot of risk. Everyone's sort of go through every day. Probably, I mean, maybe it could be also related to health reasons as well. Maybe the conductor's one, and maybe the mind him not my sound too, because of other reasons. So there's a lot of risk that involved in that long being in a team as well. So this is although this one is quite broad in a sense, but I think we try for addressing the issues of non-performance number 2. Thank you.
Thank you, Honourable Minister. Any further comments on that clause? Otherwise, let me put the question. The question is that clause 65 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 65 therefore stands part of the bill. Next clause for consideration is clause 66. Any member wish to comment on that clause before I put the question? Clause 66. Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Minister for Informed Committee, the current practice of this one, time an employee had me apply for voluntary retirement, retirement benefits plan. What now? Government had me give him plan. Thank you.
Thank you, Honourable Leader, Honourable Minister.
Thank you. So the current practice here, 50 to 54 years old, but that's currently also under review. And once that is done, then I think the rest of the entitlements should also qualify for taking. Thank you.
Thank you, Honourable Minister. Any further comments? Otherwise, let me put the question. The question is that clause 66 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 66 therefore stands part of the bill. Clause 67. Any member wish to comment on this clause before I put the question? You can refer to page 54 of the committee report on this clause. Any comments on this clause? Thank you, Honourable Leader of Opposition.
Yeah, thank you. Recommendation 35, Law Bills Committee, long reference in now clause 67, subclause 3, is for term or other person. Yeah. So resignation not effective until the relevant commission or other person who appointed the employee accepts the resignation. Well, there are only 2 appointing authorities. Not one delegated authority, no longer the permanent secretaries for level 5 and below. So I have no recommendation to that other person to be specifically permanent secretary. That's my first comment. The other is with regards to resignation. Sample resignation, lo here, resignation is not effective until relevant commission or the appointing authority may accept them. But you also have situations where employee him resign and him buy him out. Notice period below him, resignation. So that resignation below him he effective immediately. company might employ him, so or need him right away, or to just pay him off no more notice period requirement, pay him come government. That situation would now not happen under these provisions. Thank you.
Thank you. Honorable Attorney General, I wish to intervene. Thank you.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. That I'm covered under Labour Act. You say, or terms and conditions law, resignation kind of Labour Act I provide for. So that's it. Either in lieu, you pay him in lieu of notice, or you give notice. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader.
So by him no inconsistent with the provisions there, that could still apply.
Right.
Oh, thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question. There's no inconsistency and him no clash. Thank you, Mr. Chairman.
Thank you. Honorable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Major select for addressing no recommendation 35. Other personnel is more appropriate than Permanent Secretary, as other heads of agencies such as Auditor General, Ombudsman, etc., if delegated such powers by the Commission. So if you put them Permanent Secretary, have me restrict him that one. So other person by me more appropriate and relevant. Thank you.
Thank you, Honorable Minister. Honorable PAC Chair.
Chairman, I'm not part of the question him to other person. Do we refer to them as person or position? Because they can be different person occupying that post, for instance, over a period that situation like this might occur. So do we refer to them as person or position? Refer come to the definition of not allowing person is same as the positions in the public services. Thank you.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman. If MP for Central Manila said, repeating come with me. Thank you.
Person, that person, is it a person, natural human being or position? Or how do they define them? Possibly interpretation, general provisions act or lawyer, not all emotion. So is it a position that they resign to or the person, emotion? Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. Person in this instance could be sometimes learns a lot, or suddenly Prime Minister may make that appointment, or the maybe the leader of the opposition, him also office blame make him that one appointment. So him na him cover for him this one. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. With that comment, let me now put the question. The question is that clause 67 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. Clause 67 therefore stands part of the bill. Clause 68. Honorable members, again, there is an amendment proposed to this clause as appeared in the provisional business paper number 63, and let me ask the Minister to move the amendment. Honorable Minister.
Thank you, Mr. Chairman. Sir, I move that clause 68.2 is amended by deleting paragraph B and substituting the following. B, the number of employees required to perform the functions of the position is reduced. C, of a government policy for redundancy.
Thank you, Honorable Minister. Reason behind the amendment, please.
Thank you, Chairman. Yes, the purpose for this amendment just to also again make clarity law that paragraph number. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. And I do want to thank the Minister. That amendment is based Law Recommendation 36, Law Bills Committee report. The grounds of redundancy here are all work-related, whether functions here or positioning abolished. But there will be times when government policy now for right size, maybe hard economic times, government are raising enough revenue or what kind, something or something. So government should have a legal basis to be able to then make those decisions, even though those functions may still be required or the positions are still required. But economic circumstances or other considerations requiring government to make that kind of macro policy. And so that's why the recommendation 36 proposing to have something there as the basis for government to be able to do this exercise. Thank you.
Thank you. Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. I'd like to acknowledge my comment, blow Leader of Opposition. Thank you.
Thank you. Any further comments on that clause? Not, I will put a question. The question is that clause 68.2 is amended by deleting paragraph B and substituting the following. B, the number of employees required to perform the functions of the position is reduced, or C, of a government policy for redundancy. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 68 therefore stands amended accordingly. Before I put the question in respect of clause 68, does any member wish to comment on that clause as amended? Thank you. If there is none, I'm going to put the question. The question is that clause 68 as amended stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. Clause 69. Any member wish to comment on this clause before I put the question? Clause 69. Thank you. If there is none, I'm going to put the question. The question is that clause 69 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 69 therefore stands part of the bill. Clause 70. Again, there is an amendment proposed to this clause as appeared in the provisional business paper number 63. Let me ask the Minister again to move the amendment. Honourable Minister, please.
Thank you, Mr. Chairman. Sir, I move that clause 70 is amended. A, in clause heading substitute, code responsible, unquote, with code authorized responsible, unquote, and B, at the start of the clause, substitute, quote, the responsible officer, unquote, with, quote, the authorized responsible officer, unquote. The purpose of this amendment is to accommodate recommendation 37, sir. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you. If there is none, let me put the question. The question is that clause 70 is amended. A, in the clause heading substitute responsible with authorized responsible, and B, at the start of the clause, substitute the responsible officer with the authorized responsible officer. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 70 therefore stands amended accordingly. Before I put the question in respect of clause 70, does any member wish to comment on the clause as amended? Thank you, Honourable Leader of Opposition.
Thank you, sir. The spirit of that recommendation 37 is that it is critical that these authorized responsible officers carry out this responsibility. So when they don't carry it out or don't carry it out well enough, then it does have an impact on performance management and ultimately on performance. And then the accountability for that should also lie with them. So there is an accountability loop. The authorized responsible officer makes sure that his unit, the people in his unit are performing. And if they're not performing, it comes back to him. So it's from that aspect, come back Lohemia, that responsibility, accountability for him now. How do we do that? Where is that in the bill? Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman, and again, thank you, Leader of the Opposition. So in terms of performance management process, it will be entailed in the orders, which is in clause 1 to 5. For the case of responsible officers, such as permanent secretaries, the bill may provide for this accountability through the PS performance, the PRC, which is established in clause 42. Thank you.
Thank you, Honourable Minister. Any further comments on that clause amended? If not, I will put the question. The question is that clause 70 as amended stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 70 as amended, therefore stand part of the bill. Clause 71. Any member wish to comment on this clause before I put the question? Clause 71. Thank you. I see none, and therefore I will put the question. And the question is that clause 71 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 71 therefore stands part of the bill. Clause 72. Again, honourable members, there is an amendment proposed to this clause as appeared on provisional business paper number 63. Again, let me ask the Minister to move the amendment. Honourable Minister, please.
Thank you, Mr. Chairman. Sir, I move that clause 72(2)(c) is amended by inserting the following after commission. Exercise the powers granted by the Public Service Commission in section 35(2)(2). Unquote.
Thank you, Honourable Minister. Again, expound on the reasoning behind this amendment.
Thank you, Chairman. Yes, so this amendment had me for clarifying another power of discipline, had me delegated go to PS.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable MP for East Arare.
Thank you. Is it my understanding that we're still discussing the whole section or still on the amendment part? Thanks.
Yeah, repeat the comment, please.
On the, just the comments on the amendments
Yes.
for now?
Yes.
Okay.
Honorable Minister.
Thank you, Chairman. So let me know, get him clear what now. MP Blow is
He was
around.
seeking perhaps explanation on the reasons for the amendment.
Thank you, Chair. Sorry for the confusion. Just to make a comment on the other parts of the section of the clause, not necessarily the amendment.
After we pass the amendment, then
Sure.
I'll refer that question back. So, Honorable Leader of Opposition.
Thank you, sir. Under Law Recommendation 38, Law Bills Committee, the recommendation was for a mandate to come here, Law 72, Clause 72, where hemi require or hemi mandating collaboration between this professional standards unit with other integrity institutions inside law machinery below you mean some suggestion all of there and of course because they're dealing with information that may be personal and private, perhaps also confidential, they should then be required to take an oath of secrecy, but obviously that recommendation is not taken up in the amendment, and I'm just wondering whether there could be this amendment could be further amended more to take, or another amendment more to take account of that mechanism for collaboration. Thank you.
Thank you, Honorable Minister.
Thank you, Chairman. So, with regards to recommendation of the 8 Below Committee, the current practice now is that there's a memorandum of agreement signed between the institutions for MITIM now, with the requirements of their function provided in other various acts. So, in terms of data and also, currently we're using MOU or MOA for sharing of information.
Thank you, Honorable Minister. Honorable Leader.
Thank you, sir. That seems to be a sort of a transitionary mechanism between agencies, and MOUs here, obviously not as strong, obviously, as having it in the law itself. This example that me cited before, when the Auditor General issues his reports, and reporter come lo yumi lo here, and PAC is then supposed to pick it up and then come lo floor. It hasn't happened this year, unfortunately. But generally, even if after you may deal with him lo here, it's perceived as, or it's taken as dispensed with, and then nothing happens, no accountability for these reports. But if the law mandates that the PSU, because I'm not part of a spearhead law disciplinary process for investigations and also is to collaborate, then it therefore Auditor General or any another agency, Ombudsman or ICAC, would collaborate a little bit more proactively, and so PSU has access to the information that they have, and then it takes it up in its own cases, or if it has a case, they might refer out, are there other things you know about this particular case that they could benefit from? Our experience with, the police, for instance, have signed MOUs with a number of our ministries and so forth, but that collaboration is still not what it could be. And so mandating in law might be stronger, might be better. Thank you, sir.
Thank you, Honorable Leader. Honorable Minister.
Yeah, thank you, Chairman. Thank you, Leader of Opposition. Yeah, so some of these agencies still also got an active guiding work program. Those issues are also addressed inside those acts, especially with regards to information. So what normally immediately start normal is you have an agreement that you may be able to share this information, but the protection of this information I'm already stipulated on the various relevant laws below. Thank you.
Thank you, Honorable Minister. Honorable Leader.
Yes, no, I grant that other agencies have their own legislation. Auditor General, for example, Constitution and Bar are clear. But all we're doing here is we're mandating the Professional Standards Unit, which is directly under this bill, under the ministry, and therefore they can be more proactive in that collaboration. There's nothing in the legislation of Naroane, I can't think of anything that would preclude them from such a collaboration. If you're able to collaborate on the basis of an MOU, surely you're even better placed to collaborate, mandated by law. Thank you, sir.
Thank you, Honorable.
Thank you. Let me ask AG for maybe help for clarifying that issue. Thank you.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question. Just for clarity purposes, is this this is the question in relation to 72C, yeah? Maybe if you clarify and come on, Leader, please.
So thank you. So I mean, the recommendation here is for another subclause. So maybe 1, 2, maybe a new 3, to then mandate the Professional Standards Unit to seek to collaborate or to collaborate with other integrity institutions. Thank you.
Thank you, Mr. Chairman. As it is, I think it is insufficient because these other bodies have their own legal mechanisms that they can also come in with them too. But as it is now, I think functions Bluhemity, it's clearly enough that them shall include him for collaborate with him or the other agencies here too, including also the Anti-Corruption Commission. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, the problem is it hasn't been happening. It needs a cure. So, you know, if you leave a Muslim, they're all working in their own silos. And so, you know, another agency for finding information, he must go repeat him whole process for finding more information. And also, problem here. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for those comments. We'd have to see it in the context of what each functions are. Like for this one, in terms of misconduct, how do they elicit the same information in terms of MCL or whatnot becomes misconduct? Whereas for, let's say, Auditor General, if I'm requesting coming from whatnot ambit, what I'm requesting, so those, it could be problemsome especially when each one government own, let me say, set of criteria, so want of word, we're also liking for illicit amount from each agencies. Like for this one, for professional standards unit, it would be basically in terms of the offenses in the public service would be misconduct, basically, no, primarily. So if, let's say, for example, Auditor General game outcome report below him, and some officer him outlining there as being alleged embezzlement that could form part of a misconduct investigation, then that's when him reach out to all of these organizations for illicit amount what no information him requiring. But if for him say in terms of another offense, but him cannot. So that's why I think, like as it is now, it's sufficient for that purpose. If you want to expand that purpose, then of course then by images add him go more sample. But for this purpose in terms of misconduct, it is sufficient. But I get your point that sometimes you will say, I usually say it's the laws okay, it's the operators that time for me do now. They don't come up for give him evidence, they don't come up for standby, what or tell him. Everyone's makanya mo tell him, money mo tell him come tell him also kind of say. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Honourable Leader of Opposition.
Yeah, I was hoping for a kind of situation where by operation of law, the PSU would pick up on anything that's found by Ombudsman that may relate to misconduct, Auditor General that may relate to misconduct, and so forth. So that get no wait for any formal referral or anything. By operation of law, it is their duty bound to pick up that report and run with it. And same with the leadership code, obviously secrecy issues, law leadership code. But if we have that mandate, I think by him, this is a serious problem because, Auditor General's report out, no accountability right across the whole echelon of responsibility. For some of those issues. That also is highlighting the depth of this problem, and it needs a cure. So me noting there is sufficient provision here for that, unfortunately. That's why I'm saying I think we do need to further amend this amendment and include in something to fix this there. That way PSU is become positioned proactively now. Thank you.
Thank you, Honourable Leader. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for those insights. You are correct. This one here is basically triggered by referral. I get your point that you want someone that does not act upon referral, but once in their own initiative, they can go out once they see something. Yes, that law here we'll see it's basically triggered. It's most provisions law kind units or same. They're more of a guard dog rather than a hound dog kind of situation. Only police and customs or that they have those powers, and immigrations. They're the ones cloaked with powers that sort of have that kind of, foresight or something like intention, like initiative that they go on their own because they guard. Taxman, a tax you must know. You must pay more revenue, customs, revenue, immigration, security border. So those they give them those powers that have that outreach initiative. Whereas a number of internal bodies like that, they're triggered on referrals. But policy, if it changes, that can change. So as we go on, we'll see what if ministry have like for changing that one, then we'll certainly take that up. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader.
Thank you. So I suppose that's my question from policy standpoint. Do you want to change that and improve the PSU's more proactive disposition or no more? If no more, you may leave him no amendment, you move him, But that would be a terrible thing. If you like for changing, then you may further improve more this fellow amendment. Thank you, sir.
Thank you, Honorable Leader. Any comments from the Minister or Attorney General? It's a policy matter. Honorable Attorney General.
Maybe just give him just a bit of insight, and maybe Minister may complement what we tell him. One of the things in previous discussions for other similar type of bodies was time we go out, sometimes people might use it as vengeful something, and so that was how to protect against him. That was one of the things. So that times he also would refer to them until he will see what the mechanism by him to protect him that part. Kasi nigut na yung miskonta po mo baka spoiler one talk lo mi takit go na kasi. And so him not like us him yet for get him stronger mechanism before we start to do that too. So thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Minister.
Thank you, Chairman. Thank you, AJ and Leader of Opposition for those comments. I think that those are important comments that we can take on and look into how we can improve as we go along. But as I said, currently, what is only possible for us now is to use him as a memorandum. Thank you.
Thank you, Honorable Minister. With that comment, let me move the question. The question is that clause 72C is amended by inserting the following after commission. Exercise the powers granted by the Public Service Commission in section 35(2). End of quote. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 72 therefore stands amended accordingly. Before I put the question in respect of clause 72, does any member wish to comment on the clause as amended? Honorable MP for East Arare.
Thank you, Chair. 72E, as it stands, assist in protecting employees who make public interest disclosures. So this notion of public interest disclosures, are we to understand that the standard professional standards unit will be determining what is a public interest so that they can do the protection of the employees? Thank you.
Thank you, Honorable Minister.
Can I ask the AG for further clarifying on, please? Thank you.
Attorney General.
Thank you, Mr. Chairman. I don't think it will be the body to determine public interest. This one is more of an investigative kind of a body rather than as opposed to a determination kind of. So him just saying whether this misconduct occur or no more, or no more. So I don't think it will be the body responsible for determining public interest. Thank you, Mr. Chair.
Thank you, Honorable MP for East Arare.
Thank you. I think we've already discussed the issue throughout this bill as well, in terms of what now public interest is, and the fact that that is something, of course, it's not defined here, but it's defined by our jurisprudence and our courts of what public interest could be. But as it stands here, I mean, I hear what the explanation is here. Is there another phrase we can use instead of this phrase, or is it subjective? to the whistleblower, the employee, just to make some sort of a disclosure that they deem themselves to be public interest. Because as we've already discussed, that phrasing has a certain connotation to it that the courts have made pronouncements on. Thanks.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for East Arawi, for that question. Let me just look at the Whistleblowers Act. So that clause, is it 72, subclause 2, paragraph E. When you public interest disclosures under the Whistleblowers Act, so by me taking that term public interest as what is expanded or you within the Whistleblowers Act. So it's not something that ought not by determined, but it will be something that is determined under the Whistleblowers Act as being a public interest disclosure under that Act. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Honourable MP for East Arawi.
Thank you, Chair, and thank you to the Attorney General. Would we be able to see the reference there in the Act of public interest disclosures as in the context of the Act itself? Would that be something that we can reference there? Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Arawi, for that question. So, as you can see, the wording in E is basically Wakablo's PSU is also assist protect him too, or its employees were doing that one. So, okay, in the law Whistleblowers Act, I'm saying defining public interest disclosure as to mean a disclosure of information that, if true, would tend to show that an individual or body has engaging or intends to engage in conduct that constitutes a corruption offense, maladministration, or misconduct in office. I am now public interest disclosure defining. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments? I put the question, Honourable Leader of Opposition.
Yeah, thank you, sir. Just in terms of experience so far since 2018, those a number of complaints or reports where Kamlo Disfala unit under Protection Blood Disfala legislation, Whistleblowers Protection Act 2018. Obviously, ESU is not the repository of those, but they would have maybe numbers of reports where the seeking now protection under law Disfala. Do we have that kind of data? Do I get the feeling that Disfala active no ni using no man? But man ko complain lo Solomon Star ko complain lo social media no, but or not really using the legal protections that exist under Disfala legislation. Thank you, sir.
Thank you, Honourable Leader of Opposition. Those were observations, comments, right? Question. Honourable Minister.
Yes, thank you, Chairman. Currently, most of the cases that I'm investigating have come from public, mostly come from the ministries. We got some medium come submission from PSU through the commission. So currently, we have not got any of those issues that have been raised by the public. Most of the issues that we've been dealing with may come from the ministries in terms of misconduct. Thank you.
Thank you, Honourable Minister. No further comments on that clause. I will put the question. The question is that clause 72 as amended stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 72 as amended therefore stands part of the bill. Clause 73. Any comments on that clause? Clause 73. Thank you. If there is none, I'm going to put a question, and the question is that clause 73 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 73 therefore stands part of the bill. Clause 74. Any member wish to comment on this clause before I put the question? Thank you, Honourable Leader of Opposition.
Yes, recommendation 39, Law Bills Committee report. Of course, it's a much take a step back and look at a broader picture. And so when well, the recommendation speaks specifically about when there's proposal for legislation that cabinet procedures require each piece of legislation and doing analysis law, the manning levels or the additional workload that will be created and therefore additional workforce requirements. So you may pass in stark a law for good, but you may never do the necessary work to understand how many people now are needing for implementing that piece of legislation. And of that number of people, how many do we already have in existing positions in the public service, and how many now additional? Of course, this is a matter that comes back law office below you too here, Mr. Chairman. Office below Speaker, before you satisfy the nuclear MCAM bill, or tabled, and then its committee have me deal with him. I think order 43 or order 44 have me require an additional analysis for him satisfying you, both on the fiscal burden that it would bear on the budget and the manning levels, the manning burden it would bear on the payroll in terms of how many more additional employees now you may need him. So this recommendation is in that spirit to, perhaps Cabinet already has it in its handbook, we're not sure how it's implemented, but that any proposed legislation, it must come within a bit of work analysis here, so that Cabinet look like, oh yeah, you said, oh no, this one, him with something, but you know, got enough people for doing it. You know, last time, Mr. Chairman, you may pass him this Electoral Act 2018, and you may say, oh, but you may do him continuous registration as an example. Eh? Well, we haven't done it for a number of years because that kind of analysis wasn't done. Same with him, Ombudsman Act, the time you may pass him. Bayagot Garem offices law province. Kasim this time, no matter one file office, no 80. So we have this tendency of passing wonderful looking sounding legislation, but almost oblivious, almost neglecting the need to understand manning levels requirements. So when we talk about workforce development planning, that is an important aspect. One, you know, in that recommendation 39, let me talk a little bit about reverse engineering, looking at the workload and then working backwards to see how many people now need him. Of course, it would be better looking forward. And that's why when a ministry proposing or sponsoring a piece of legislation is going around in consultations, and especially internal, intra-government consultations, those consultations are supposed to be addressing those issues as well, resourcing issues, human resource issue and the finance resource issue, to say that, yeah, you must have a good law and you must have implement him, you must have sustain him. So that's the spirit of that recommendation 39, sir.
Thank you, Honorable Leader. Honorable Minister.
Thank you, Chairman, and thank you once again, Honourable Leader of Opposition. So in terms of the workforce needs, currently that's been addressed through the annual establishment. Workforce needs have been identified through the HR development plans and performance management Form 1, and for each ministry developing the bill that will have cost and manpower implication. And this has to be consulted with the Minister of Public Service and the Minister of Finance. So that process is already in place. Thank you.
Thank you, Honorable Minister. Honorable Leader.
If process is in place, because we still have these laws that you may pass in, but you may not are fully implementing. Either the assessments have been inadequate or laws have deliberately been over-ambitious. Thank you, sir.
Thank you, Honorable Minister.
Yeah, thank you, Chairman. Thank you, Leader of Opposition, for that additional comment. Yes, I think we agree on that. This is something that the Minister of Public Service and we continue for work with the various ministries, because those needs have to be identified by the various ministries. We could go with him that we need to improve those processes, and we take note of that. Thank you.
Thank you, Honorable Minister. Any further comments on that clause? If not, let me put the question. The question is that clause 74 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 74 therefore stands part of the bill. Clause 75, any member wish to comment on this clause before I put the question? Clause 75. Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Recommendation 40, Law Bills Committee report. The context is that training of public officers, government ministry lose control of him, and Hemigolo Saitesa. And so then Saitesa has this internet portal where applicants for scholarships or now applying or now determine what now by what study as long as it's eligible disciplines within the opportunity list. It has nothing to do with the fact that agriculture needs more technical people, or mines, geology need more technical people. No more interest logot officers here. So government actually lose control of having direct supervision over own training needs. Either government doesn't know its own training needs, and therefore leaving more money to level, or by default ministry let them go that responsibility lo Saitesa. But if it did that, it seems to me it wasn't well designed, and so Saitesa by the send come list lo ministry for say ogat public officers or sem now ogat apply come shortlisted, and then by ogat ministries kick around mona for finding money I go who by film a place here or I'm going training training when priority or kind of issues also. So now recommendation 40 MCA no more control law training requirements law civil service. It must be a matter for Ministry of Public Service. Now I'm coordinating with every ministry, but it needs to be coordinated. It needs to be a cohesive whole. Saitesa him for facilitating no more rather than him now determine them. Thank you, sir.
Thank you, Honourable Leader of Opposition, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Yes, I agree with him. What now comment where the leader mentioned him. That is actually the challenge that we face him currently. But in this bill, that will be addressed. What will happen now is instead for those training same go through Saitesa, it will come first to the training board, which by established under section 76 of this bill here. And from there, not before, you may give back Los Atesa. Thank you.
Thank you, Honourable Minister. Any further comments on that clause? If there is none, I will put the question. The question is that clause 75 stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 75 therefore stands part of the bill. Clause 76. Does any member wish to comment on this clause before I put the question? Clause 76. Thank you, Honourable Leader of Opposition.
Yeah, clause 76, sir, recommendation 41, along Bills Committee report. Again, me go a little bit broader, take a step back. And firstly, me say clause 75, when deal with him training policy here, now must inform him clause 76, what the training board must do, must do him. And in so doing, the board itself needs to be a radar capability looking forward and seeing areas of need. Of course, must look at the present situation and current need so that at most, if not all times, the public service is fit for purpose and is as efficient as possible. Not one more than is required officers so that we have idle hands, but certainly shouldn't be one less than is required and therefore affecting effectiveness of delivery. So it must always be at optimum manning levels. The other, sir, is having a more proactive disposition, this for training board, so that it's doing outreach into high schools and our universities. And you may pick him over top math students or physics students or also in our high schools. You may start them a program where he encourage him over now. Again, time out go to university, you may incentivize him scholarship. And then time out come out, or to go to mines and energy or geology or also now. They've been spotted young talent, been nurtured, incentivized, and you may put them on the right place. Or no go no more hemi. Pick him something where I'm good too, but I'm not as strategic to the country and to the civil service. So it's, the recommendation is looking for something a little bit more proactive from that training board as opposed to just receiving reports and making decisions, that it's supported to become proactive in selecting, nurturing talent. Mr. Chairman, thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of Opposition. Yeah, so basically, the overall human resource management need assessment have come from the Ministry of Planning. One of them addressed a different ministry level. Public service and deal with public servants. Most of the technical or needs that have been addressing the needs of the private sector have been done by the Ministry of Commerce. So, this issue can be addressed in the policy as in clause 75 of the bill. Thank you.
Thank you, Honourable Minister. Honourable Leader.
Yeah, thank you. Yeah, so this recommendation is focused on public service, human development, or human resource development functions, and then its training policy and the way the board will transact itself with a proactive outlook with outreach and also, and that's why earlier on one of the clauses you need to deal with internships and volunteers also. Committee also recommended for you increase him here, make him part of that whole stream now is pathway blogger. They can come into internships and then hopefully they find it fruitful working in the public service and they can remain long term. So yeah, the focus of this is public service. Of course, this just as well applies also to the private sector. Yeah, thank you.
Thank you, Honourable Minister.
Thank you, Chairman, and thank you, Leader of Opposition. We take note on those recommendations, and we will address them through the policy and also the public service order. Thank you.
Thank you. Honorable Chair of the Bills and Legislation Committee and West Harare.
Thank you, Chairman. 76 for me looking at some policy law port composition. But Tintinoma law ministries, imikara mo kata DSs, even no kata directors, we kata karam experience and no kata long time law ministry. Some serve more years than permanent secretaries who are appointed on contracts. If Minister care to just explain to the committee. Thank you.
Thank you, Honorable Minister.
Yeah, thank you, Chairman. Thank you, the Chairman of the Bills and Legislation Committee. Yes, as you rightly tell them, there are other staff would, like the directors and DSs go there. Under this bill, the PSM got empowered to delegate, so that issue can be addressed here. Thank you.
Thank you. Any further comments on that clause? Not. I'm going to put the question. The question is that clause 76, term part of the bill. Those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 76, therefore, stands part of the bill. Clause 77. Any member wish to comment on that clause before I put the question? Clause 77. Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. This was 77-1 year now. Member Blow Central Honorem like for apply for Putum Law this was review committee for the PSY. Yeah, man. Something awesome for establishing. My comment, law, this one no more, is at some stage in the future, it would be good to move IPAM to become a statutory authority, public administration training, but ME statutory authority, so we can attract some really good talent, some professors and experienced people, and pay them for what it would take, and they're not tied to public service pay structure, but also that there is some serious investment in the in our research capability, so they can do research that will enhance the public service performance, public service work, effectiveness, and other areas, perhaps even go beyond just public service staff training and look to facilitate, perhaps not itself offering it, but collaborating with SINU and other more specialized institutions, facilitate some technical professional education programs for, Sakalot officers below me. That way we don't need to send them to places overseas to do that, and they're away for a couple of years, but could be done through the institute. But for us to be able to do that, it does need to be at an arm's length from the public service itself, the ministry itself, so that it can attract and retain the requisite level of qualification experience you may need. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Honourable Leader of the Opposition. Yes, so the progressive thinking on the IPAM is to actually really move it away from the ministry and make it as a standalone institute. Thinking is that it will become a school of excellence for public service. So that is really the thinking on how we can progress the work of the IPAM as we move on. Thank you.
Thank you, Honourable Minister. Honourable Leader.
This one bar of good thinking to us, Mr. Sewan. School of Excellence, and me told Minister Blow Women, let's go on most excellent school too, the weekend, and talk about thinking about School of Excellence. Lo sif lo antabe bata. It's a good culture to to encourage. And part of that one, sir, is even ministers, even all of us, members of parliament, we need continuing professional development. No good meeting you may sabe every something no nothing no. Or some you also have stuck something, but even those who know a lot need upgrading too, yeah. We get more modern information, we know more. And those of us who are struggling with issues, we at our own pace too are helped to move up. And so that's why if it becomes sort of, you know, a statutory authority, and then obviously for me members, it would have to be voluntary rather than compulsory, but then it's open for everybody who has a role in the wider civil public service, serving the people in trustee of capacities. Thank you, sir. Even you, Mr. Chairman, you must go to or teaching good law standing order lawyer. Something or same. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Once again, I'd like to thank you, my Leader of Opposition, for those insights. We take note of other comments. Thank you.
Thank you. Any further comments? Not, I'm going to put the question. The question is that clause 77 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 77 therefore stands part of the bill. Clause 78, again there is a proposed amendment. The Minister will introduce the amendment before we consider the amendment. Honourable Minister, please.
Thank you, Mr. Chairman, sir. I move that clause 72 is amended by substituting paragraph E with the following. Quote E, online learning as a mode of study. F, monetary cost for all levels.
Thank you, Honourable Minister.
Yes, thank you, Chairman. This amendment is to enable the IPAM for use of digital technology. Thank you.
Thank you, Honourable Minister. Honourable members, before I put a question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. It's a good amendment, and especially for GAREM mandatory courses for every level of civil service, so everyone's being equipped and being armed to understand the laws that apply to their mandates, how to implement, execute in practice, reporting, something or seven. So as they rise through the ranks of the public service, they become more and more effective in the discharge of their responsibilities. So this is a very good amendment to tighten those things up. Thank you.
Thank you. Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman, and I'd like to say thank you, Leader of the Opposition, for this comment. Thank you.
Any further comments on the proposed amendment? If not, I'm going to put the question. The question is that clause 78(2) is amended by substituting paragraph E with the following. E, online learning as a mode of study. F, mandatory course for all levels. All those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 78 therefore stands amended accordingly. Before I put the question on this clause as amended, does any member wish to comment on this clause as amended? Thank you, Honourable Leader of Opposition.
You know, big something to us, but lot 2D, 772D. This well, words relevancy here. This one, I think, this time part of a new language, modern language, I think, but meeting same relevance no more. Design, inform course designers on the relevance of training programs. Not relevancy, but anyway, no small something, no much relevance D, but ini sa one meaning na. Thank you.
Thank you. Your comments, Honourable Minister.
Thank you, Chairman. Sorry, me now really capturing what now? Leader Mexican, can you please repeat that?
Sorry, Honourable Leader, can you repeat your... Attorney General?
Maybe if you repeat him, come back more.
I'm just the word relevancy, law 772D. Should it just be relevance? Or by correct term no, power blue law, legislation act.
Thank you, Mr. Chairman. It is incorrect. I would say inform course designers on the relevancy of training programs. Relevancy. Yeah, I think okay. It's just choice of words, no thing. Yeah. Thank you, Mr. Chairman.
Honourable Leader, you were making reference to clause 77, which we had already disposed of. Yep, you already voted on it. You didn't vote. Yeah, we are on clause 78. Already amended clause 78, and the call now is for any comments on that clause 78 as amended. Again, any comments on the clause 78 as amended before I call for your vote, Honourable Leader?
Yeah, thank you. 78 as amended. Me testing you know about? Hey. So 78.6, sir. A member may be reappointed but may not be appointed for more than 2 consecutive terms. This restriction beyond 2 consecutive terms of office. The policy rationale for that. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of Opposition. Yes, so we believe that 12 men should be sufficient for a month from several there, which is 6 years. Not even keeping one month too long there, they would become stale and stagnant. Thank you.
Thank you, Honourable Minister. Honourable Leader.
Example, type man, or get a kind man when no more 20 years, you will keep him replace the same. We serve good law constitution, although we get no lawyer, we serve good law general orders, we serve good law how system of public service must work. On what mana is yamane? You try come mining lo brain blame by telling you everything lo general order and or something. Kan man osem no 10, 15 years you mean like him sit down no place osem. So rather than constraining it to two consecutive terms, leave him open, then leave him discretion lo minister na for exercising judgment no more. For example, no more money I'm good, but at this time something I'm not really remember now. Oh, I was saying let her go now, but if I'm still good at it, hey, I'm not, you mean need him? Also, that's the concern. Thank you.
Thank you. Honourable Minister.
Thank you, Chairman. Me take note of important discussion leader where mentioned him. Thank you.
Thank you, Honourable Minister. Honourable Chairman of PAC and MP for Central Honiara.
Thank you, Chairman. I think to Vale same number, 77 and 78. So question me and ask him number, will it be accredited to the, what name, call him, Higher Education Authority? Higher Education Authority, below you me? Because, you know, we, side law, the quality assurance law, qualifications that will be issued by this institute here. So, will that be the case, Minister? And if so, how number by you doing beside? Mina looking law, yes, part of the functions law. Thank you.
Thank you, Honourable Minister.
Chairman, thank you. And before Senator Honara, yes, so the thinking now is for you may accredit him, I permit with him and attach him with him several institutions. So currently we have a lot of partnership with Public Service New Zealand and New South Wales. So we are in discussion for looking how we can do that as we go along. Thank you.
Thank you. And with that response, I will now put the question. The question is that clause 78, as amended, stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 78, as amended, therefore stands part of the bill. Clause 79. Again, there is an amendment proposed to this clause. It's appeared in the notice paper. Honourable Minister, please, can you move the motion for the amendment?
Thank you, Chairman. So I move in clause 79, substitute permanent secretary with a code A, permanent secretary unquote.
Thank you, Honourable Minister. Please expand on the reasoning behind the amendment.
Thank you. This is one hand just for clarifying number 2, because that the clause for make him clear number. So purpose is for just to clarify that clause if it become more clearer.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
Thank you, sir. And therefore, where now the permanent secretary would be held to the requirements where Part 8, imposing on everyone else. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Sorry, get him clear. Can you please repeat that statement, please?
This amendment here, the original proposal, Hemi referred to the permanent secretary, so that would be permanent secretary for public service. But the amendment, Hemi said to a permanent secretary, so meaning every permanent secretary. So they are not included. The misconduct is not included here, under Part 8. But what good something now, Part 8 here. So where now the permanent secretary be held accountable or conduct blocked. Thank you.
Thank you, Honourable Minister. Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. I think why it's kept that way is because anything for permanent secretaries for discipline, I think go back to Public Service Commission, so we don't deal with it here. Thank you, Mr. Chairman.
Thank you. Any further comments on that? Sorry, Honorable Chairman, PAC.
Yeah, so you know, taking that explanation, then why are we also carrying out there's a provision there for, what name call it, PSRC, public service, they are not included in that assessment, or the earlier provision that we were talking about, that charged with the responsibility for, is it Permanent Secretary? Chairman, you are helping me? Go back to the page.
One that we already voted on.
Yeah, but that's the one that I was referring to. You know, if they're part of the performance in this.
42, clause 42.
42, yes, absolutely. You true now. I'm not me thinking law. Chairman, I'm about pick him now. Yeah, that's it. So there is the performance of the permanent secretaries. So that is performance, isn't it? Yeah. Low performance of the permanent secretaries. This act can cover now assessment of their performance. But when it comes to misconduct, we take them out from this, and then we put in more the law. The other legislation. Oh, is that what is happening here? So we are not. They are not included in any misconduct or assessment or something or similar. Please, AG.
Attorney General, please.
Thank you, Mr. Chairman. The reference in 42 is basically just for performance. Normally, you're evaluating performance. In terms of fire and hire, I'm still staying within Public Service Commission, including discipline of permanent secretaries. This is just to review their performance of Wakabluketa, number 42 in Thailand. So that's why in 80, is it 80? No, 79. We still maintain that in terms of for misconduct investigating water, blow Public Service Commission too. Thank you, Chairman.
Thank you, Honorable Attorney General.
Chairman, but him also refer to, there are two options there. One is alleged misconduct, yeah, and the other is unsatisfactory, whose employment is unsatisfactory. So, what do you regard as unsatisfactory? Their performance? So, they could be covered too. Look at clause 79. There are two options there. In terms of their employment is unsatisfactory, so that is something to do with maybe performance now. And then there's another option, which is alleged misconduct there. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. If you take it in the context of this part, meaning the employee have come for that for partner, because it comes to conduct, as a conduct, you go to the core function below Public Service Commission. So that's why permanent secretaries are excluded in this partner. So to include them would be to go against or go a local function below Public Service Commission. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Thank you. If there are no further comments on this clause, I will now put the question. The question is that in clause 79, substitute the permanent secretary with a permanent secretary. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 79, therefore, stands amended accordingly. Any comments on that amended clause 79? If not, I'm going to put the question, and the question is that clause 79 as amended stand part of the bill. Those in favor, please say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 79 as amended, therefore, stands part of the bill. Clause 80. Any member wish to comment on this clause before I put the question? Clause 80. Thank you, Honourable Leader of Opposition.
Yeah, thank you. So recommendation 45, Law Bills Committee, a general recommendation no more. Specifically referencing Olketa diplomatic foreign service Bloyumi, so that I'm sure, again, pardon my ignorance, by Chairman of Foreign Relations and Prime Minister no Savage Law Tiswal area, but conduct law people who represent us to other governments and international organizations and so forth. Just judging from our interactions, log at important events, and even, time you may go overseas and also, I've always wondered about our understanding of protocol and dress and etiquette, and it's simple something where there are no big substantive issues, but they do, unfortunately, they do count. Issues of alcohol use or abuse, what kind of something was saying, because time, of course, functions are an important tool in international diplomacy. So the code of conduct for foreign service personnel, a little bit take him on some extra, perhaps more specific guidance than a general one where he must comply with him too, but applies right across the public service. So a general recommendation, this one, number 45. Thank you, sir.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman, and thank you once again, Leader of the Opposition. So the Code of Conduct cover now every public servants. Regulations and orders applied for all the public offices, including officers in embassies and foreign missions. However, a specific mandatory pre-departure and ongoing training programs in diplomacy, etiquette, cultural awareness and national representation is a responsibility of the Ministry of Foreign Affairs in collaboration with other ministries. This can also be further addressed, law or the regulations and orders after me passing the bill. Thank you.
Thank you, Honourable Leader of Opposition.
Thank you. Perhaps the Honourable Prime Minister, given his years of international diplomacy and experience, could enlighten the committee. How is that done at the moment? Is there a set of foreign service rules, and is there training, law diplomacy, and all that kind of stuff? Thank you.
Thank you, Honourable Prime Minister.
Thank you, Mr. Chairman. Let me thank the Leader of Opposition for that important question. Because, of course, foreign affairs officers, they are public servants. There is no separate cadre asset for foreign service, but we do have overseas foreign service regulations that does cover some of the areas that the Leader has alluded to. Thank you.
Thank you. Any further questions, comments on that clause?
Chairman.
Chairman of PAC.
Yeah, Chairman. So clause 80 will not apply to PEM secretaries, isn't it? Clause 80, it will not apply to PEM secretary, a PEM secretary.
Honourable Minister.
Thank you, Chairman. The answer is no.
you, Honorable Chair, PAC.
Yeah, what the man with to Masnay, what PM secretary. So where will they be captured in terms of putting a guard law, their conduct law overseas here? Chairman. What the man with travel to Masnay, what PM secretary. Other employees, you man stable no more. This my comment is in relation to subclause A here, 80, that occurring in Cholmans or another country. So where will permanent secretary or a permanent secretary will be guided, against any possible misconduct? Yeah. Thank you.
Thank you, Honorable Minister. The Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Central Honiara, for that question. As I alluded to earlier on, anything to do with discipline and finding also discipline, termination, or some handle public service. So it would be proper to have it in the Public Service Commission regulations as opposed to Public Service Bill. Just for question, leader of the official opposition, this one applies to Foreign Service in any event, this clause. You will see that this is one of the first legislation where you may apply, we call it extraterritorial effect laws, believe me. So you go outside the jurisdiction. Most of our laws you may apply within jurisdiction, but this is one of the first times which we now extend our laws to our citizens going out. So it has an extraterritorial effect. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Any further comments on that clause? If there is none, I'm going to put the question. The question is that clause 80 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 80 therefore stands part of the bill. Clause 81. Any member wish to comment on this clause before I put the question? Any reference to the report, please refer to page 63 of the bill's legislative committee report. Any comments before I put the question? If I see none, and therefore I will put the question. The question is that clause 81 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 81 therefore stands part of the bill. Clause 82. Any member wish to comment on this clause before I put the question? Clause 82. Thank you. If there is none, I'm going to put the question. The question is that clause 82 stand part of the bill. Those in favor, please say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 82 therefore stand part of the bill. Clause 83. Any comments on that clause? Thank you. Honourable Leader of Opposition.
Yeah, thank you, sir. I'm just wondering, good fair process, this one. I'm just wondering how long would this take on average for applying now procedures here? Where I start law 82 now, but I'm also law 83. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Yeah, so with regards to the question, by the time we develop the public service order now, by me addressing the Felicia.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Yeah, no good na another 3 months more than man where me stop no more law calls up somewhere, but him no himself like for self-terminate, him no resign and also you give him 3 months law him. Then one under law here inability for perform. Another 3 months more. We are carrying a lot of dead weight in the budget to and hold him about positions. Therefore, if we add them all together, that's a lot of public service pay and time that's not being utilized. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, the opposition leader. So that has been maybe for nice more these details. That means we work along public service order. But me acknowledge him for the comments, please. Thank you.
Thank you, Honourable Minister. That note, let me put the question. The question is that clause 83 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 83 therefore stand part of the bill. Next clause for consideration is clause 84. Does any member wish to comment on that clause before I put the question? Clause 84. Thank you, Honourable Leader of Opposition.
So for clause 84, recommendation 46, Blue Bills Committee, I suppose would like for looking where misconduct may also criminal in nature, that an appropriate referral is required so that the matter is not merely dealt with through the administrative processes and also and then finish there now and no referred, because this has been the case for quite some time now. Public service misconduct has just merely been dealt with in the public service law. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Let me ask MAG for maybe clarify if I'm wrong. Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Just leader, if just no clear law question. Thank you.
Thank you, Chairman. I suppose by any apply law misconduct, so by any Division 3, Division 4, even go here, Division 4, I think clause 86, just so that at the present time, if a report is received by the Permanent Secretary about misconduct, any minor or major, then the appropriate process may go now. If that for misconduct, presumably major, any involving some criminal elements, at present time, that process and internal or public service no the time out determine and conclude lo there now. And then any disciplinary measures are taken within bounds of public service rules no more. The recommendation here is to say immediately upon determining that there are possible criminal elements in such reports of misconduct, that by operation of law, it should be referred immediately. They've never had one referral, all of police law matters, when they even thought some criminal elements involved. Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. Previously, we had what they call the third felony rule, and that meant that once criminal go, disciplinary thing stop, civil stop. Just recently, the courts here hold that that does not apply here. So you decide you bisa running parallel everything. So with this and all that, okay, if criminal proceedings go, disciplinary proceedings have run, even civil proceedings have run simultaneously now. So with your, I think just recently there's one case which we employ that one. So although with the criminal element running, misconduct go ahead too. So I think him in relation to one for I think a police officer where criminal proceedings go on at the same time. There's disciplinary, they're not like appeal against him, disciplinary proceedings at High Court. So him run simultaneously. So the moment last time sometimes criminal come, what man just wait no more. Then what after criminal, then what side put come back law disciplinary. But now as soon as criminal go, you just give him come any reports. So therefore, permanent secretaries continue with the misconduct law this one. Thank you, Chair.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, thank you. That's good, clear. I suppose my concern is a matter is reported through the public service process law here, not law police or any other agency, because I'm concerned I'm a public officer. And then upon determining that there's possible criminal elements to that conduct, and then Permanent Secretary must refer him or something also. The process for him run parallel, that's great. But that referral for him happen immediately upon determining that, hey, this one him look also him criminal too, yeah. Then him go ahead to administrative one, but him refer him go to police, carry him on process blame too. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for those questions. Currently, practice is as soon as we give advice, we refer to police, DPP. But actually, I refer to the DPP, and DPP proceeds with what he needs to do. If he's looking as a criminal offense, him give him go to police commissioner for a carrying on further. So, time Permanent Secretary right come with for an advice on this conduct. Once we, in giving the advice, we see that there's a criminal element to it, we will say that there's a criminal element to it, and we will also at the same time refer that to the DPP. So that's the process currently going on. And this one, just that doesn't change anything here. Thank you.
Thank you, Honorable Leader.
So that would work if you are doing that. That would work only for the misconduct they're seeking advice from your office. But presumably there are some misconduct cases where they can determine it without seeking advice. With those, about a referendum go to, or that's the concern. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. In that regard, the Permanent Secretary should be able to refer it immediately upon his determination of that fact. Usually, everyone by like send him come, which is always the case, and then let the Attorney General's Chambers make that determination on an advice first before carrying on. So usually we do that before him go back law. Permanent Secretary in any event. But if Permanent Secretary can do that, law start and go, that's perfectly fine. They can do that. Thank you, Mr. Chairman.
Thank you, Honorable. Okay. You were going to.
Oh, yes, okay. Well, maybe we encourage it in the rules or also that Permanent Secretaries are doing. Go misora lo maita Attorney General to man. Stuck something where you should not refer him no. Because of everything no, he must decide to advise him come. So Permanent Secretaries need to just get on with it. But anyway, I think he should come to rules that PS refer him matters where him criminal in nature. Thank you.
Thank you, Honorable Leader. Honorable Minister.
Thank you, Chairman. Acknowledge my comment below. Leader of Opposition. Take note. Thank you.
Thank you. And with that, let me put the question. The question is that clause 84 stand part of the bill. All those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 84, therefore, stands part of the bill. Our next clause is clause 85. Any member wish to comment on that clause? Clause 85. Sorry, Chairman, the Council. Okay. My apologies. It's now 4:30, and the proceedings of this committee has to be interrupted, and Parliament will resume. And I understand the Prime Minister wishes to move on suspension of standing orders to allow deliberations of the committee to continue. Thank you. Parliament is resumed. Honourable Prime Minister, please.
Mr. Speaker, it is now 4:30, and I move that Standing Order 10 be suspended in accordance with Standing Order 81 to permit the continuation of the business of the House until adjourned by the Speaker in accordance with Standing Order 10.5.
It is granted, Honourable Prime Minister. So the Honourable members, the question is that Standing Order 10 be suspended in accordance with Standing Order 81 to permit the continuation of the business of the House until adjourned by the Speaker under Standing Order 10.5. All those in favour, say aye. Those against, say no. I think the ayes have it. The ayes have it. Standing Order 10 now stands suspended, and the business of the Committee of Supply will continue until I interrupt it to adjourn the House. Thank you. The committee is resumed. Clause 85. Any comments on the clause? If I put a question, thank you, Honourable MP for
Chairman.
Central Honiara.
Yeah, Chairman, I think this is a very good one. In terms of reporting load misconduct, like for instance, in the case of the leadership code, you can, I think, you can actually receive complaints from the public, and then the leadership code can act on those reports. Yeah. So, in terms of sub-clause 1, yeah, I think it is good that reports are made internally from employees, and also I guess that option for other personnel would also include the public or other personnel. Thank you, AG. Because I think we should open it up to the public to also make this report, so that that can itself provide that kind of a guardrail against possible misconduct, that the public are watching us. Thank you, Chair.
Thank you, Honourable MP for Central Honiara. Attorney General.
Mr. Chairman, thank you, MP for Central Honiara. Is this the reference to 4B3 or that person or other person? No clear.
Chairman, other person in sub-clause 1, number 85, paraphrase line number 1. An employee or other person who suspects or believes that an employee is committed, they can make a report here. So will that other person can also include the public? Me supporting public and should also make a report here. Thank you.
Thank you, Honorable Attorney General.
And thank you, Mr. Chairman. Thank you, MP for Central Honiara and Chairman PAC. Short answer, yes. Addition him, any other person, him, open him up. That even on the public, him, got a complaint about him, this a certain public servant, then him like for, make him report to him, and then him. Thank you, Mr. Chairman.
Chairman, I think this one about best something low billion. That public and watching me and they have the provider in charge of this new billion for make a report, emotion, against any possible misconduct. Law, you me everyone here now, emotion. Emotion, yeah. Im karakil go no. Yeah.
Thank you, Honorable PAC Chair. Any comments, response to that observation or comment by the Chairman of Public Accounts Committee, Honorable Attorney General? Minister? Silence means consent. Thank you, Honorable Minister.
Thank you, Chairman. Yeah, me, the able, but I go past so concentration a bit lose too, man. But anyway, yeah, I think that one of the policy intention brought that for closure. Thank you.
Thank you. Honorable MP for East Arare.
Thank you, Chair. So 85 for B, not Roman 3. Oh, Roman 2. I think it might be helpful for me. Let me try to look at the possibility of, instead of the person, we say the employee to whom it is made. Because the next one talks about the person who made the report. Stuck a person's name inside of there, but wouldn't it be more helpful clarity if we say, keep the following record, the employee to whom it is made, the report now. With that confuse things more, it might help me. We're focusing on the employee. Employee, of course, is defined already in this bill. Thanks.
Thank you. Honorable Minister. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Arare for that question. Now, if you see law 85.1, say the employer or other person who suspects that in something when they're doing wrong, he must report him go null or responsible officer of that ministry. Okay, so they make come for him said responsible officer who makes a report under 2. So him out him na wait. So time after him come give him report, 2 him say that a responsible officer must make him report na on behalf of the person who complained. So the day him say so report where him make him he must include him na keep record no date where this whole person make him complain him make him also 2 who na this whole report where him come make him lo him. So say if him say Peter na him come make him lo him, so the report was made on the 4th of February and it was made to Peter. I say to whom it was made, No, not to whom him made, and not to whom it was about. Also, but to whom it was made. So Peter na him say. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable MP for East Arare.
Thank you, Attorney General. I think law 85.3, we see that the responsible officer who suspects or believes that an employee, so employee party no mana, I think him now, this will report there. The record is supposed to be for the employee to whom that report is made to. And then, of course, the person who made the report too, and the persons, and you know, all these other. I'm just looking at some persons normal there, but maybe it might be good for clarifying that we're talking about the person to whom it's actually the employee to whom the report is made. Awesome. And then, of course, the other persons, including Ogatawe Mekem report, to Manwe report, and Kamian, contact Blomania, these other, yeah. Just thought it would be clearer if we put that one there, if that's the intention, that we're 85 4B2 is actually talking about employee. So that we may get away from the persons and just talk about the employee. Would that make sense or no more? I'm not what we're intention here. Thanks.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Isara, for those comments. I think the intention is clear that the same responsible officer, where you make him report under Section 2 and number, you must make him keep him clear now. The following anecdotes where him saw at law 1, 2, and 3. I'm saying that so lo date lo number 4 February dim golo pita na receive and pit and who man make him reporter. It could be a different person making a report. He might report him lo pita, but pita responsible officer lo him lo tuval na polo. You say so polo no okay same. So that's why instead of the person is just kept broader. So you just plain language name issue. So that's the use of and also use of those words. Thank you, Mr. Chairman.
Thank you, Honorable MP for Isara.
Thank you, Chair, and thank you, Attorney General. I think we understand him. Lot people we make him report me. I think it's not really about the person in the subject of the report. It's the trail of paper trail. Is that the intention here? Okay. Thank you.
Thank you. With that, let me now put a question. The question is that clause 85 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 85 therefore stands part of the bill. Clause 86. Any member wish to comment on this clause before I put the question? Clause 86. Thank you, Honourable Leader of Opposition.
Is comments law recommendation 48 law bills committee relate both to 85 and clause 86. First matter is the interface with the Whistleblowers Protection Act. If a reporter opts to make a report under the Whistleblowers Protection Act. The other aspect of him is interference or undue influence in the handling of misconduct allegations. That if that interference or undue influence is by a public officer, that constitutes major misconduct. My name might say, hey, bro, no, you see, no more. Here, a little bit fish and chips here, or kind of something also. And then also, Attorney General, let me touch on him a little bit earlier today when we were dealing with, trying to prevent frivolous and vexatious accusations being made, and so taking up resources and time for look law keta. So there's some protection against that, so that one, the option of reports being made under the Whistleblowers Protection Act, clear for everyone for using. At the same time, there's accountability for responsible officers whilst ensuring that the integrity of the misconduct investigations is protected and a just outcome is reached. So I have now the spirit of recommendation 48, where we cover both clauses 85 and 86. Thank you, sir.
Thank you. Honorable Minister.
Thank you, Chairman. I'm asking my AG for clarifying whether this will be led by ME harmonized with now the Whistleblowers Act. Thank you.
Thank you, Honorable Attorney General. Sorry.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition. I don't think by him there's a clash. Like if we see in the professional standards unit, one of their jobs is to protect people who are whistleblowers. In this sense, the bill does not, you may say, him no clash with him. See, the point here is the people who in the high echelons could be the ones that are recommendation him query, yeah? That they could be susceptible to external influences. Now, we have all these other say legal mechanisms already in place, like in anti-corruption, whistleblowers, ombudsman, even public service commission regulations would be also where if someone sees that this happens by permanent secretaries, that's where they channel their grievances to go to public service commission. Also we have Royal Songhai's Police. If any such activity or looking happen, then they could also report that. But then that comes to boils down to the person making a complaint actually coming forth with those complaints too. Sometimes people just make it, earlier on you might state that Facebook no more count with him, but time for actually go and testing what provisions here, no one's actually taken that initiative to go and actually use those provisions to make sure such persons are held accountable. You may Facebook no more, full-time with man back a complaint, but time you may say you go refer him, no one does that. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. There are no further comments on that clause. I'm going to the motion. The question is that clause 86 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 86 therefore stands part of the bill. Clause 87. Any comments on that clause before I put the question? Clause 87. Thank you. If there is none, I'm going to put a question, and the question is that clause 87 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 87 therefore stands part of the bill. Clause 88. Any member wish to comment on the clause before I put the question? Clause 88. Okay, if there is, sorry, Honorable Leader of Opposition.
Yes, just one comment, Longo. misconduct, not for amend them or go back Lohemo, but the matters raised in recommendation 49, perhaps in some regulation or rules. Ministry Salululukulan, the matters that are very likely criminal, so other laws, but Namimi Garem cyber security law by should also cover, but updates law, penal code, believe me also, but a system in place when these kinds of activities happen with regards to public officers or use of public resources. That matters also are pulled up for accounting. Law volunteers, law clause 88, sir, recommendation 50, law bills committee, with regards to the restriction, law 2 here, sub clause 2, PS must take all reasonable steps to ensure that volunteers are not used for work which the public service would reasonably be expected to pay, or 2A, or to perform functions that are generally performed by an employee, 2B. Just in the situation that we may have volunteers that also we discussing, I think yesterday, or VSO or JICA or not JICA, JOCB, where experienced people come, they're paid by their own volunteer organization and can do the work, but 2A and B pretty much restrict him what work they can do now. So, thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Acknowledging the comments were raised, and the recommendations me also address this was close to 88 here, so thank you for this comment. We take note of a lot of things where Leader Henry mentioned. Thank you.
Thank you, Honourable Minister. Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question. Maybe just for, I note that the recommendations below BLC is that the restrictions here might be too rigid. They are there for a purpose. One is this all protection against slavery, the Constitution blaming Potom. Now, if we start engaging in activity that will require professional services, professional thing, you see, you have to qualification where if that person would, that job would have required someone with a qualification to do, and then you put on a volunteer him with for no pay, you could be bordering slavery, saying you no pay me, you like me work nothing no more. So for that, something just to maintain that protection, we need to have this kind of rigid restriction on him, because sometimes we say, I'm right, we quit no more, kind of still, you must avoid you now, because time was come, the government might be seen as engaging in that fella conduct where Constitution blame him but prohibit him now, that he may not do him. So that is basically why we have a rigid condition there. And also too, that time condition blame for coming doing voluntary work must be clear at the start. This is what you come for doing for voluntary work. Do you agree? Time agree for come doing voluntary work, then him do. But time come him no agree, you know, we come no voluntary, then this one too, the one, party me also must be cautious about when we start for engaging to voluntary service. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments? Honourable MP for East Arare.
Thank you, Chair. I think probably already partially answered, but volunteers we're referring to here, does it include him too, or what the overseas volunteers here, or what the local volunteers no more.
Thank you, Honourable Minister.
Yeah, thank you, Chairman. Thank you, MP for Mr. Arare. Yes, the answer is yes. But in addition to what AJ mentioned today, the volunteer agreement by motion stipulating the task that the volunteers by order engaged inside. Thank you.
Thank you, Honourable Minister. There are no further comments. I'm going to put a question. The question is that clause 88 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 88 therefore stands part of the bill. Clause 89, honourable members, there is an amendment proposed to this clause, appeared in the provisional business paper 63. Let me ask the Minister to move the amendment. Minister, please.
Thank you, Mr. Chairman, sir. I move that clause 89 is amended as follows. A, substitute subclause 3 with the following. 3. Arrangements under this section may A. Second an employee from one ministry to perform functions for another ministry or for a provincial government, or B. Second an employee to perform functions for a body outside the public service. B. In subclause 4, insert code in subsection 3B and code before code is responsible, unquote. C, in subclause 5, 1, delete paragraph A and B, and 2, restructure the remaining paragraphs in alphabetical order. D, substitute subclause 6 with a new subclause as follows. 6, in this section, code body and code refer to an organization or institution outside the public service. Thank you. The purpose of this amendment is to make more clarification on the secondment process. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Recommendation 51, Law Bills Committee report now, referencing the matters that the amendment may try for further clarifying. So we appreciate the intention of this fella amendment. So yeah, thank you.
Thank you. Any other comments on that amendment, proposed amendment? Thank you, Honourable MP for East Arare.
Thank you, Chair, and thank you for these amendments proposed by the Minister, of course in accordance with the recommendations by the BLC. But Law, the last one there, when it refers to body, it refers to organization or institution outside the public service. Is it the understanding or intention to hear that this also means institutions outside of Solomon Islands? Regional, international, awesome? Or him just for UMI inside our country? Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for East Arare. The answer is yes. Thank you.
Thank you, Honourable Minister. Any further comments? Otherwise, I'll put the question. And the question is that Clause 89 is amended as follows. A, substitute subclause 3 with the following. 3, arrangements under this section may A, second an employee from one ministry to perform functions for another ministry or for a provincial government, or B, second an employee to perform functions for a body outside the public service. B, in subclause 4, insert in subsection 3B before before is responsible. And C, subclause 5, 1, delete paragraphs A and B, and 2, restructure the remaining paragraphs in alphabetical order. D, substitute subclause 6 with a new subclause as follows. 6, in this section, body refers to an organization or institution outside of the public service. All those in favor say aye. All those against say no. I think the ayes have it. The ayes have it. Clause 89 therefore stands amended accordingly. Before I put a question in respect of clause 89, does any member wish to comment on that clause as amended? The Bills Committee report is findings and recommendations on the clause on page 66 of the BLC report on this bill. Any comments on that, on this amendment as proposed? Thank you, Honourable Leader of Opposition.
Here, the second part of that recommendation 51, Law Bills Committee, let me say the preferable situation would be to leave to the public service orders or secondment instrument of it matters well, or subclause 5 here. D9 reference him in particular, so that there is maximum flexibility and any might case by case by any different. So the amendment law here, HEMI no deal with that matter specifically. So I'm not that a big issue to us, but just me put on record no. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Let me note him comment below, Leader of Opposition. Thank you.
Thank you. Any further comments on the proposed amendment? Zero unamended clause. If there is none, I'm going to put a question. The question is that clause 89 as amended stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 89 as amended therefore stands part of the bill. Clause 90, any member wish to comment on this clause? If I put the question, clause 90. Thank you, Honourable Leader of Opposition.
Yes, sir. Law 90, subclause 1. The term implied requirement. And then again, more subclause 2. Statutory office holders or holder also holds office subject to implied conditions. You know, why do we want implied? Why not expressed? Thank you, sir.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. So, subsection 1 in this matter implies, it makes it when you perform those functions, law terms and conditions, law employment law, it sort of ties in cannot values law start law here as an implied term and condition law engagement law when you perform your functions. So in terms of when you hold them accountable, that's you read also those values in addition to your terms of reference law, law engagement plea or functions plea. Okay, thank you, Mr. Chair.
Thank you, Honorable Leader of Opposition.
So it's not, it would detract from that if we said expressed requirement or expressed conditions. It would mean something different now. Implied just seems a bit passive, that's all.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition. Initially, you will see that what time you say why you put in the values, yeah? Those values serve as you say what guiding principles. So they form an implied term in your contract, for example, as opposed to an explicit term. So termination, once you redeem apply mode finish, then you shall say, okay, in addition to the above, the values that you have to show in when performing your functions are also this one. So it's sort of a guiding kind of a principle when it comes to other statutory office holders when they perform their functions. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. That note, let me put the question. The question is that clause 90 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 90, therefore, stand part of the bill. Clause 91. Any member wish to comment on this clause before I put the question? Clause 91. Thank you. If there's none, I'm going to, sorry, Honorable Leader of Opposition.
Yeah, thank you. Just a recommendation, 52 law okay, the very special temporary employees. Yeah? You know, I suppose the big picture on this matter is bringing political appointees into some kind of a more disciplined framework that whilst it is a necessary part, it doesn't interfere with the public service, and at the same time it does not attract a disproportionate remuneration compared to the public service. Those have been issues over an extended number of years. So it's a concern that was raised with the committee by a number of stakeholders. But here, of course, in the recommendation, just the name, political appointees here, and of course the ministry explained that this one had become no longer the current instruments and practice. But it's just the broader issues that were concerns that were expressed to the committee. Thank you.
Thank you. Thank you, Honorable Leader. Honorable Prime Minister.
Thank you, Mr. Chairman, and I do thank the Honorable Leader for those comments and observations in terms of the broader issues surrounding political appointees, not only at OPMC but the Office of the Leader of Opposition, the Office of the Independent Group. So these are issues we look forward to addressing them, and I do thank the BLC for recommendation 52 on this particular matter. Thank you, Chair.
Thank you, Honorable Prime Minister. Any further comments on that clause? If not, I'll go to put the question. The question is that clause 91 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 91 stand part of the bill. Next clause, clause 92. Any member wish to comment on this clause before I put the question? Clause 92. Not, let me put the question. Sorry, Honorable Leader of Opposition.
Thank you, sir. Clause 92 definition of complainant. It means an employee. So it cannot be any other person now that could be a complainant. Thank you, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Please, can Option Leader comment, please?
Just the law clause 92 definition, law, the word complainant, means an employee. So only an employee can make a complaint, and no opening for others. Thank you.
Thank you. Honourable Minister.
Yes, thank you, Chairman. Thank you, Leader of Opposition. Yes, so that every feedback law, employee grievances, so only the employee or the complainant is the employee. So this with regards to the grievances law or the employee. Thank you.
Thank you. Any further comments on that clause? Otherwise, let me put the question. The question is that clause 92 stands part of the bill. Those in favor, please say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 92, therefore, stands part of the bill. Clause 93. Any member wish to comment on this clause before I put the question? Clause 93. Thank you. If there is none, I'm going to put the question. The question is that clause 93, some part of the bill. All those in favor, say aye. Those against, say no. I think the ayes have it. Ayes have it. Clause 93, therefore, stands part of the bill. Clause 94, any comments on that clause? Before I put the question, clause 94. Thank you. If there is none, I'm going to put the question. The question is that clause 94 stand part of the bill. So those in favor, please say aye. Yes. Sorry. Honourable, apologies. Honourable MP for Small Malaita.
Hey, thank you.
Sorry.
You promoted me.
It's arrived.
I feel very promoted now. Yeah. Very privileged. Thank you so much, Chair. Thank you for recognizing me. Just to get the intention correct here, who is aggrieved by an action, would this also relating to employees' employment? Would this also mean inaction or action no more? Could the interpretations might say also inaction too, just to get the intention right here. Thanks.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Sarare. In administrative law, to do an act is an act, and to not do an act is an act. So both ways work. By you choosing not to do an act is a motion. You are doing an act, and just to clarify, we know that one. So it covers both sides. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Honourable MP for East Harare.
Yeah, thank you very much. And of course, it's already in the definition law, previous section here. What about omission? Aggrieved by an omission. Is that also covered under this? Do you think so? Thanks.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. If Mr. Clarify, aggrieved by omission or what does it? Because the omitting to do an act is actually an act. So you can you can complain about the omission to do an act, which is the same as not doing an act. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. And with that, let me put the question. The question is that clause 94 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 94 therefore stands part of the bill. Clause 95. Any member wish to comment on this clause? Clause 95. Thank you. If there is none, I'm going to put the question. The question is that clause 95 stand part of the bill. All those in favor say aye. All those against say no. I think the ayes have it. The ayes have it. Clause 95 therefore stands part of the bill. Clause 96. Any member wish to comment on this clause before I put the question? Thank you. Honorable Leader of Opposition.
Yes, one Lord Division 2 complaints. So me like complain no, me baru start hagar no kunai. So Minister by anything lo kitchino. Lomo sub clause 3 complain me make him on behalf of the chairman. Lo sub clause 3 chairman. A complaint must be made within 28 days after the action is taken. Just the pragmatic situation, Nomolo, given the sparse distribution of islands, Bloimi, and some officers are out in remote locations. By the time they know of an action that has been taken, maybe beyond that 28 days, thereby extinguishing the time window. Thank you, sir.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman. 28 days is the actual let me say, standard time for making a complaint, appeal, everywhere we're looking. Usually the old style is 30 days. And this time we put 28 days because you say 1 week of 7 days, 4 weeks, 28 days, so that's the style. Okay, but then the next clause now for have said that if Public Service Commission or responsible officer have looking at their exceptional circumstances for doing so, and that scenario which leader you come is an exceptional scenario in one scenario where courts have always extended time on distance-able. So even now at courts, court filing rules that if you stay within 1 year or no more, then yes, you have this 28 days timeline. But then if you lo Makira, there's a 10 days addition to it, and if you lo Temotu, another 28 days on top, so 2 months or so. Because take into account too that transportation, internet connection, connectivity, also, but now with every towers going up, we might have faster connections or for you misaddressing, but yeah, courts have generally recognized the need to extend time based on those circumstances, and the law have told that what to follow what persons were receiving here, and they have the authority to extend the time based on those exceptional circumstances. So thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Any further comments on this clause? If not, let me put the question. The question is that clause 96 stand part of the bill. Those in favor, please say aye. Against say no. I think the ayes have it. The ayes have it. Clause 96 therefore stands part of the bill. Clause 97. Any comments on that clause before I put the question? Sorry, honourable members, honourable minister, there's a proposed amendment to this clause. As appeared in the business paper 63. Please, Minister, you move the motion, move the amendment.
Thank you, Chairman. Mr. Talem, they have over so you start overlooking on paper. I agree with it. No more school good. Paper promulgation was finished too, Chairman. So if you need to continue, you need to take a call before me read right. Thank you, Mr. Chairman. I move that the clause 97.2 is amended by substituting the word cannot with the word may.
Thank you, Honourable Minister.
This amendment they have me really for correcting that fella subclause 2 and thank you.
Thank you, Honourable Minister. Any comments on the proposed amendment before I put the question? Thank you, Honourable Leader of Opposition.
Yes, thank you, sir. Just to reference it to recommendation 56 of the Bills Committee report, where and stakeholders that appeared also say that there may be incidents where more than one employee have a common share in issues of a common complaint and should therefore be allowed to lodge such a complaint together. Thank you, sir.
Thank you, Honourable Member. Honourable Minister.
Thank you, Chairman. I would just like for acknowledging my Leader of the Opposition. So that amendment I made for accommodating recommendation 56, which perhaps allow more than one person for raising complaint. Thank you.
Thank you. Any other comments on the proposed amendment? If not, I will put the question. The question is that clause 97.2 is amended by substituting the word cannot with may. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 97 therefore stands amended accordingly. So I put the question on this clause. Does any member wish to comment on the clause as amended? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Recommendation 57, Law Bills Committee report. Let me talk now about a standard complaints form so that all the requirements contained in this bill about complaints, lodging of complaints, content of complaints, or everything, make it consistent and comply with the requirements of the law. Here the recommendation was so that, that should be mandated here, but it could equally be mandated by regulations or perhaps even public service orders or rules, something also. Thank you, sir.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. So, forms are important tools of the public service. Specific forms will be provided in accordance with the orders and regulations. Electronic forms will also be used when digital technologies are introduced in the public service system as amended in clause 49. Thank you.
Thank you, Honourable Minister. Honourable Leader.
Yes, so we encourage the ministry to liaise with IPAM and then time training this for law IPAM or also training to lodging complaints and not forms. So the current process, sir, is just let them know I'm like lodging complaint and file him write him let them know and give him go. So some letters may be informative, others may not be. Some may contain all the requirements to enable a process to commence. Some may not be, but a standardized form will help to ensure that the process will become more efficient. Thank you.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Chairman. Thank you, Leader of Opposition, for those comments. May take note. Thank you.
Thank you. Any further comments on that clause as amended? First, let me put the question. The question is that clause 97 as amended stand part of the bill. Of those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 97 as amended therefore stands part of the bill. Clause 98, any member wish to comment on this clause before I put the question? Clause 98. Thank you. If there is none, I'm going to put the question, and the question is that clause 98 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 98, therefore, stands part of the bill. Clause 99, honourable members, there is an amendment proposed to this clause as appeared in the provisional business paper 63. I therefore ask the Minister to move the amendment. Honourable Minister, please.
Thank you, Mr. Chairman, sir. I move clause 99(2)(c) is amended by deleting the word quote, major, unquote.
Thank you, Honourable Minister. Need you explain the reasons behind the wording amendments or the wording amendments?
Thank you, Chairman. Just clarifying good number, the intentional subclause C. Thank you.
Thank you, Honourable Minister. Honourable members, before I put the question, does any member wish to comment on this amendment? There is none. I'm going to put the question, and the question is that clause 99(2)(c) is amended by deleting the word major. All those in favor say aye.
Aye.
Against say no. I think the ayes have it. The ayes have it. Clause 99, therefore, stands amended accordingly. Before I put the question on the question, clause 9 is amended. Any member wish to comment on that amendment, on that clause as amended? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Recommendation 58, Law Bills Committee, I mean, referencing this well clause 99, and especially on the matter of making malicious complaints. So maybe law antap longo 99(2)(b)(1, I'm already tell him responsible officer or commission must caution him now this for complaining against him making frivolous, vexatious complaints or complaints in bad faith. But to go further, perhaps a clause D may be to say that malicious complaints which I may obviously filled with malice and bad faith too, but a little bit go too, is major misconduct. So that right from the word go, complainant may sabe that there is accountability also for try for abusing this fellow process. Thank you, sir.
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Honourable Leader of Opposition. Those comments are noted. Thank you.
Thank you, Honourable MP for East Arare.
Thank you, Chair. In the spirit of modern drafting, maybe me changing what the word frivolous, vexatious. Let me say no good complaint. No. I mean, you may go throughout this while I draft here and you can simplify name to do him, and then all of a sudden you may go Latin now. Here one time. Is there a way that we could also look at this one? Because I think there are certain definitions probably already tied to some of these words here, frivolous, vexatious, going by the Attorney General's previous interventions about need to simplify or a little bit. Making for my name reading and understanding, meeting him if I where we were pronouncing everything wrong. How I'm stuck this time here. Thank you, Chair.
Thank you, Honourable MP for East Arare. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Arare, for that question. The idea did cross our desk in trying to simplify it but then the damage that it would do no, is bahana by you may refer back to case law time you may try for settling more matters. So the term frivolous and vexatious has been settled over time as a legal phrase, and number of dictionaries, law dictionaries have identified it and defined it. So once you start out more, you start again back. So the choice to keep it as it is because of the long legal history attached to frivolous and vexatious. So it was decided that it was necessary for you to keep it more one. Thank you, Mr. Chairman.
Thank you, Honourable MP for East Ararai.
Thank you. Well noted in terms of that response. Maybe the Minister, Nugutivala Ranemini Koso, one am not meaning blow, frivolous and vexatious for what the way like make him complain, they know what it means and not run afoul of these very important sounding words. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Member for East Ararai. So after the bill and pass, we doing the socialization process. That's when the legal team I'm going to explain some of these attempts for your own understanding. Thank you.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Thank you, sir. What is frivolous and vexatious, Honourable Attorney General?
All about.
Huh?
All about. Attorney General, please. Interpretation.
Thank you, Mr. Chairman. Frivolous and vexatious, if you, in terms of going to court, is when you make an application that one I'm doing is frivolous and vexatious. It could be a number of things. It could be an abuse of court process. It could be, you may say him just no garam any reasonable cause of action. It could be basically the main ones, him no any cause of action and him abuse of court process. So in this context, it would be, you may say, person where make him come, this fella claim would be making a claim that just pluck him out of the air and no one come and give you. And no one can always come back. Some abuse of process in the court process is sometimes what come, or serial litigants, sometimes they call them, so you come back and forth no more. It could be an abuse of court process. So here, they try to address him here too, where him say that this one where you repeatedly make him complaint could be a misconduct in itself. So it's trying to address that, let me say, those forms of frivolous and vexatious where courts have in the past held as frivolous and vexatious. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. Any further comments on that clause as amended? If not, I will put that question. The question is that clause 99 as amended stand part of the bill. All those in favour say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 99 as amended therefore stand part of the bill. Clause 100. Any member wish to comment on this clause before I put the question? Clause 100. Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Me no like withdraw complaint lo me baru hagere. But look clause 100 there, sir. Look, recommendation 59. The Bills Committee report the issue lo there is no good now. Complainant here he withdraw no more because of undue influence. So a matter is worthy, a complaint is worthy of being properly dealt with, but the accused maybe using cultural practices below me or using some other undue influence or even intimidation or threat or something or so then complainant hem go apply no for withdrawn complaint lo hem time hem bimosem. In most cases, this matter no any accountability for him now. And perhaps at the personal level, their relationship may be restored, but in terms of governance, those issues may remain unresolved. So him now, recommendation 59, him try for, say there ought to be some tests or some criteria or some basis for where a complaint could be withdrawn to protect against kind also. Thank you, sir.
Thank you, Honorable Leader Opposition. Honorable Minister.
Thank you, Chairman. Sorry. Thank you, Chairman. Firstly, just for addressing the issue law recommendation there, for clearing number that withdrawal of complaints will depend on the person making complaining. If we decide for withdrawal, then we withdraw now. We have not gotten primary evidence to issue. But that issue would be addressed law clause 102, where PSM guidance, by creating the guidance for location clause 102 for governor details below withdrawal of complaint process. Thank you.
Thank you, Honorable Minister. And with that, let me put the question. The question is that clause 100 stand part of the bill. Those in favor say aye.
Aye.
Then say no. I think the ayes have it. Ayes have it. Clause 100 therefore stand part of the bill. Clause 101. Clause 101. Does any member wish to comment on this clause before I put the question? Any comments on clause 101? Thank you, Honourable MP for East Arare.
Thank you, Chair. Just for the Minister, in terms of the criteria list that we have there, the following are confidential. It seems to be very exhaustive. I'm sure I'm not missing anything there that might be need to be added here too, but you might not capture. Or are you happy with what is there? And then anything we have no law here, we have go out him right now. People here and come, but it's just that me looking at him quite exhaustive. Just wanted to know whether you were happy, Minister, with him, how it is that you're confident that what the things will remain confidential and no good any loophole. Not something think of all outside law door no one window. Law about investigations. Thank you.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, MP for East Malaita. I'm confident this process should be sufficient for addressing the issue of confidentiality law information. Thank you.
Thank you. Any further comments on that clause? No, let me put the question. The question is that clause 101 stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 101 therefore stands part of the bill. Clause 102, 102. Does any member wish to comment on this clause before I put the question? Clause 102. Thank you, Honourable Leader of Opposition.
Thank you, sir. Just a question about current practice, no more, how this is carried out. I'm presuming that complaints are received and so forth. So what guidance is issued? How is it issued at the moment? And what instrument not using for law guidance? What legal effect does it have?
Thank you, Honourable Leader. Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Yes, so currently, you assume no more general order. And also, PSM Sabi came out letters circular for guide them now, in terms of the guidance. Thank you.
Thank you, Honourable Minister. Any other comments or questions on this clause? Thank you, Honourable Leader of Opposition.
Perhaps the Attorney General could help me here. So the Lohier Public Secretary now for give him guidance about complaints and all same. So that guidance here, hemi issue law memo, circular or something or same. Because him mandated, well, him empowered by, enabled by 102, clause 102. Does that have force or equal force or some public service orders or regulations? Because it's coming, power say hemi come out from clause 102.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition. They would probably have the same level as of general orders kind of thing, which is just an administrative guideline on how we deal with things. This one, in terms of making complaints, circular, or it could be, I'm saying, normal complaint rules, or saying it could be one or the other. But as long as the person making it is the permanent secretary, then NM column, so this will be used as guidance for the internal reviews or so. Then it satisfies what 102 am requiring. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Honourable Leader of Opposition.
Yeah, thank you, sir. And then that circular or stand also unless revoked or amended by any future circular.
Thank you, Honourable Attorney General.
And thank you, Chairman. Thank you, Leader of the Official Opposition. That is correct. And subsequent guidelines will probably either amend or repeal also. And thank you, Mr. Chair.
Thank you. Thank you. Any further comments, observations, or question on this clause? Thank you. If there's none, let me put the question. The question is that clause 102 stands part of the bill. Those in favour, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 102, therefore, stands part of the bill. Honourable members, I think we have covered enough in this sitting. The proceedings of this committee is now interrupted and Parliament will resume. Thank you. Parliament is resumed. Honourable members, in accordance with the earlier resolution of the House and pursuant to Standing Order 10.5, Parliament is now adjourned until 9:30 a.m. on Friday, 24th October 2025.